Yes. Yes. So regarding my water accident application or hearing? Hearing. Malad, this is contempt application. Your lordship's pass an order in vacation bench. Malad, 12th November, the medical examination is will be conducted till 9th December. Malad, kindly takes up this matter on urgent basis and next Friday. May I discuss your lordship?
Application under section 5 in connection with second appeal.
Yes.
The application in connection with second appeal.
It is
My lord,
in connection with lordship.
Anyway, give it. It will appear as to be mentioned.
my lord, may I be left with second
SAT 309 second appeal tender.
Second appeal for what?
For eviction
No, for application or hearing.
hearing. My lord.
So mention next week.
Okay.
application for
Actually, the matter ready for hearing 2018 matter.
What second appeal?
Yes, Lord.
Next week.
Lordship hearing application, MSCC application.
Yes, MSCC.
Application.
Yes, give the slip.
This is for to be mentioned. MSCC case for to be mentioned.
The MSCC case for hearing, my lord. Matter is pending since 2008. My lord.
Yes.
For application.
Application
For application, my lord.
for
For substitution, my lord.
yes.
May I permit to mention one MSCC matter for inclusion in the list hearing.
The slip.
Number one.
Milord, item 1, Milord, I am appealing for the respondent, Milord. In this matter, Milord, I have instruction, Milord, settlement, Milord, out of court settlement is going on. Now, Milord, my humble submission, probably, Milord, they will also, Milord, make the same prayer.
Yes.
Milord, my humble
Interim
submission.
order is there.
Yes, Milord. This interim order is preventing us, Milord, from, rather them, from, Milord, withdrawing the suit, Milord, which is pending before the Alipur court. So if the settlement happens, Milord, they will go and withdraw the suit in the Alipur
Let
court.
this which application is to be decided? Can one?
Milord, your lordship modifies the order of, Milord, in Can 1 itself.
Milord, Can 1 is the stay application.
Yes, Milord. 4th of December 23. 4th December 23. Just clarifies it, Milord, that if we want to...
File any application for modification?
No, my lord, we don't want modification. It's just a liberty that your lordship would grant us that if there is a settlement, we can go and, my lord, withdraw the suit in the trial court.
Otherwise, Milord, the
Suit is stayed, so we can't go to the court, my lord.
This is the second appeal.
Yes, will. Yes.
second appeal, Milord, there was initially an order passed that all further proceedings of the suit will be shall remain
Stay.
stayed.
Proceedings of the suit or for the execution case?
Proceedings of the suit.
Proceedings of the
Suit.
suit. What is
No.
that order? Let me see. Yes.
Yes.
Yes, Milord, the initial order passed by the Honorable
4th
Division Bench.
December
Page,
23.
page.
4th December, my lord.
The order
Should be on the record. আমার সিনিয়ররা নেই কেন? Kindly have a look at, my lord, your lordship, kindly got it, my lord. Kindly have a look at on the second page. Accordingly,
Page
there
three,
shall be...
page 3.
Yes, second page, my lord. Accordingly, there shall be stay of all further proceedings in title suit number 1197 of 2022. There was a little bit of a problem with respect to maintainability as well, where the second appeal lies, where the FMAT lies. Order 7, Rule 11, my lord, was allowed by the appellate court.
So the matter,
Thank you.
so now the matter will be heard by the division, this single bench.
Yes, my
Single
lord.
bench, Milord.
Yes,
if
It
the-
admitted and it will be heard by
Yes,
the
my lord.
Yes, and the
And the stay
maintainability
was
point will be taken.
granted. The stay was initially granted by the division bench.
That has been continued.
And that
by
was
the-
continued, my lord, by the honorable single bench forever. So just a clarification that this stay will not, my lord, preclude us from going and filing, my lord, or withdrawing the suit.
Milord, provided, Milord, the settlement takes place.
Yes, yes, definitely.
Otherwise, Milord,
Why would we?
otherwise, Milord, the entire matter will become.
No, no, definitely that, definitely.
Yes, record an order. Learned advocates for the parties present. This appeal was admitted on 4/12/2023
Yes.
and in the said order dated 4/12/2023, further proceedings in title suit number 1197 of 2022 pending before learned civil judge senior division 4th court at Alipur was stayed for a period of 6 weeks or until further orders, whichever is earlier. Stop.
pursuant to the admission by the Honorable Division Bench, the matter is listed before this bench for hearing of the matter. It is submitted by the learned advocate that the parties have entered into a settlement and terms of settlement may be filed before the learned trial court. Stop. Unless the order dated 4/12/2023
It's not the appellate.
is modified, the parties cannot take necessary steps before the learned trial court for the purpose of settlement. Stop. Thus, the order dated 4/12/2023 stands modified to the extent that in the event the parties arrive at a settlement and make necessary application before the learned trial court, the learned trial court shall only consider the said application for the purpose of settlement in accordance with law.
Grateful to your lordship. Artificial document.
Lord, in case, my lord, if your lordship kindly clarifies,
in
my lord, in
terms of
case, my lord, the
settlement,
settlement does not arrive at, my lord, then, my lord, the
Come
original.
back to your
Then
lordship.
this order will not come into force.
Just-
Only when there is a settlement, the trial court will
Okay.
consider.
Lordship, kindly add one line, my lord, to that extent.
Key. In default, if it doesn't happen, the
However, in the event there is no settlement between the parties, the order dated 4/12/2023 with regard to stay of further proceedings will revive.
Lordship, grateful.
Will revive na. Revive na. Proceeding will not revive. The state of wicket revive.
এই অর্ডারটা রিভাইভ করবে
এই order টা revive করুন।
Yes, I am giving a liberty to mention.
yes will
Okay, liberty to mention.
they are a little agitated, I don't know why. Grateful. এই অর্ডারটা রিভাইভ করবে না যদি ওখানে সেটেলমেন্ট
Milord, I beg to appear for the
Was this
petitioner.
matter a part-heard matter?
No, Milord, matter has already been argument has already been completed. Milord, both the
The last
parties,
order.
both the parties have Milord submitted their written notes of argument.
Everything is complete.
Everything is complete. So this is that matter. Your Lordship may recall that the written statement was.
Yes, Mr. Sen argued the matter.
Yes. Lord, the written statement was filed, Milord, after 13 years. My submission was that, Milord, there was no reason, neither assigned by the
So
Milord,
both parties have filed the written notes of argument.
Yes, complete. Only it can, Milord, appear for orders or Milord for judgment, whatever your Lordship.
Record an order. Learned advocates for the parties are present. The learned advocates submit and it appears from record that the hearing of the matter was already concluded and the parties have already filed their written notes of
And exchange there also, exchange.
filed their written notes of arguments upon service of copy
Yes.
upon the other side. In the facts and circumstances, let this matter appear for judgment on 17/11/2025.
17.
I'm grateful to your Lordship.
Yesterday your lordship was pleased to hear out this appeal at length, my lord. Today your lordship desire to file the
Yes,
the
yes, only
citation,
some
only
writing.
citation. No further argument.
Milord, your lordship, Milord, wanted to see that consortium, Milord, as has been decided by panel city, Milord, 5 judges bench. Milord, it specifies that it should be limited to spousal consortium and rupees 40,000 only. And thereafter, Milord, there were a few, Milord, Supreme Court judgments, Milord, of Honorable Division Bench of 3 judges bench, Milord, which expanded the meaning of, Milord, consortium's word and said that consortium may also include, Milord, parental consortium as well as filial consortium, Milord, which can be given to the parents and, Milord, to the children. Milord, Supreme Court further, Milord, 1 or 2, Milord, extra cases, Milord, has also given it to the brothers and sisters as well, this consortium, by further expanding the meaning. Lord, my argument before your lordship yesterday was, my lord, that when 5 judges bench, my lord, has specified that the consortium should be confined to spousal only, either to the husband or to the widow, my lord, widow or the widow, it should not be given any further expanded meaning. My lord, the first dissenting voice, my lord, of Supreme Court against this penalty, my lord, may I show the penalty where it had indicated, my lord? I had shown it to your lordship, my lord. If my lord so desires, my lord, I can indicate the paragraph. Otherwise, if my lord says, my lord, it is not required, then I will not. Penalty,
Consider
my lord,
regarding now which judgment pronunciation is already there in the
penalty is already there, my lord. I wanted to indicate those paragraphs, my lord.
whatever it is that has to be considered.
That has,
Pronunciation.
my lord, do I need to show those paragraphs to your lordship, my lord, the consortium?
Please.
Penalty is there with my lord, my lord. May I just give a copy of that to your lordship?
Okay, the other matter you have filed
My lord,
pronunciation.
I have brought another copy too for my lord's, my lord, convenience.
Yes.
My lord, before that, my lord, since it is a 5 judges bench judgment, my lord, this judgment also deals with the issue of, my lord, the binding precedent, my lord, of Supreme Court. That why, my lord, a bench of a larger strength, my lord, would prevail always over a bench of, my lord, a lesser strength. My lord, as far as, my lord, the consortium point is concerned, my lord, I can invite my lord, to paragraph number 48 of this. And thereafter, my lord, I'll pray for your lordship to come to, my lord, this binding precedent part. Paragraph 48, if my lord is kind enough to come to, my lord.
Yes.
It's at page number, my lord, internal page 16. Another aspect, my lord, if I may read, my lord. Another aspect which has created confusion pertains to grant of loss of estate, loss of consortium, and funeral expenses. In Santosh Devi, a 2-judge bench followed the traditional method and granted 5,000 for transportation of body, 10,000 as funeral, and 10,000 as regards consortium. In Sarla Verma, the court granted 5,000 under the head of loss of estate, 5,000 funeral, and 10,000 towards consortium. In Rajesh, court granted 1 lakh towards consortium and 25,000 towards funeral. It also granted 1 lakh towards loss of care and guidance for minor children. The court enhanced the same on the principle that a formula framed to achieve uniformity and consistency on a socio-economic issue has to be contrasted from a legal principle and ought to be periodically revisited, as has been held in Santosh Devi. On the principle of revisit, it fixed different amount on conventional heads. What weighed with the court is factum of inflation and the price index. It has also been moved by the concept of loss of consortium. We are inclined to think so. My lord, this is the view of Honorable 5 judges. For what it states in that regard, we quote. My lord, the quotation is here. My lord, subpara 17. In legal parlance, consortium is the right of the spouse to the company, care, help, comfort, guidance, society, solace, affection, and sexual relations with his or her mate. This non-pecuniary head of damages has not been properly understood by our courts. The loss of companionship, love, care, and protection, etc., the spouse is entitled to get has to be compensated appropriately. The concept of non-pecuniary damage for loss of consortium is one of the major heads of award of compensation in other parts of the world, more particularly in the United States of America, Australia, etc. English courts have also recognized the right of a spouse to get compensation even during the period of temporary disablement. By loss of consortium, the courts have made an attempt to compensate the loss of a spouse's affection, comfort, solace, companionship, society, assistance, protection, care, and sexual relationships during the future years. Unlike the compensation awarded in other countries and other jurisdictions, since the legal years, Lordship will kindly take note. Unlike the compensation awarded in other countries and other jurisdictions, since the legal heirs are otherwise adequately compensated for the pecuniary loss, it would not be proper to award a major amount under this head. So take a note of, considered, and then decided, my lord, that under this consortium, my lord, other legal heirs are not to be given money. Hence, we are of the view that it would only be just and reasonable that the courts award at least rupees 1 lakh for loss of consortium. 49. Be it noted, Munna Lal so-and-so did not deal with the same, as the notice was confined to the issue of application of correct multiplier and deduction of the amount 50. This aspect needs to be clarified and appositely stated. The conventional sum has been provided in the second schedule of the Act. The said schedule has been found to be defective. So-and-so. My lord, it has again dealt with, my lord, that part. Milord, paragraph 51, subparagraph 3, Milord, is the Sarla Verma's reference, and Milord, 163 is schedule's reference, that how much is to be given. And then, Milord, paragraph 52 and 53 is the, Milord, the relevant paragraph. On the aforesaid basis, the court has revisited the practice of awarding compensation under conventional heads. Paragraph 54, as far as the conventional heads are concerned, we find it difficult to agree with the view expressed in Rajesh. It had granted 25,000 towards funeral, 1 lakh towards consortium, and 1 lakh towards loss of care and guidance for children. The head relating to loss of care in minor children does not exist. Though Rajesh refers to Santosh Devi, it does not seem to follow the same. The conventional and traditional heads, needless to say, cannot be determined on percentage basis because that would not be an acceptable criterion. Unlike determination of income, the said heads have to be quantified. Any quantification must have a reasonable foundation. There can be no dispute over the fact that price index, fall in bank interest, escalation of rates in many a field have to be noticed. The court cannot remain oblivious to the same. There has been a thumb rule in this aspect. Otherwise, there will be extreme difficulty in determination of the same, and unless the thumb rule is applied, there will be immense variation lacking any kind of consistency, as a consequence of which the orders passed by the tribunals and courts are likely to be unguided. Therefore, we think it seemly to fix reasonable sums. It seems to us that reasonable figures on conventional heads, namely loss of estate, loss of consortium, and funeral expenses, should be 15,000, 40,000, and 15,000 respectively. The principle of revisiting the said head is an acceptable principle, but the revisit, your lordship will kindly take note, the revisit should not be fact-centric or quantum-centric. It has been made absolutely clear, my lord, consortium, first of all, dealing with entirety, should be confined to spousal. The quotation has been made, and it should be 40,000. Revisit should not be fact-centric, my lord, or the quantum-centric. We think that it would be condigned that the amount that we have quantified should be enhanced on percentage basis in every 3 years. My lord knows about this. My lord, we had indicated
on the
lordship. And the enhancement should be at the rate of 10% in a span of 3 years. We are disposed to hold, so because that will bring consistency in respect of those heads. My lord, these are there. And then, my lord, this has culminated in paragraph 61, last but one page. My lord, the penultimate page. My lord, the Roman 8. The last, my lord, the last paragraph is, my lord, that last but one page, paragraph 61. My lord, this culmination is there. Point 8, my lord, reasonable figures on conventional heads, namely loss of estate, loss of consortium, and funeral expenses should be 15,000, 40,000, and rupees 15,000 respectively. My lord, the paragraph 61 starts with, in view of the aforesaid analysis, we proceed to record our conclusions. So, my lord, my point today before your lordship is Pranay Sethi took note of various division bench judgments, various 3 judges bench judgments, took out the meaning of the word consortium, dealt with that, decided the issue that it should be confined to spousal consortium only, nothing more, nothing less. Because, my lord, for children also, my lord, for the children, 1 lakh was granted. Court said, Pranay Sethi, that no, that head is not permissible. No separate 1 lakh to children. Only spousal consortium, along with, my lord, funeral and, my lord, loss of estate. This is what, my lord, the finding of Pranay Sethi is 5 judges bench. Now, my lord, the first আরেকটা কপি মন্দিরে আছে আরেকটা কপি দাও আছে এখানে ওর মধ্যেই আছে Milord, first dissenting voice, Milord, came out in the case of Nanuram. আরেকটা কপি ছিল ওতেই হবে Milord, Nanuram, Milord, expanded the meaning of a division bench of Honorable Supreme Court, Milord, extended the meaning of Milord consortium. And it said, Milord, over and above, Milord, the spousal consortium, it should be given, Milord, to the parents or, Milord, to the children as well. Milord, this was dealt with, Milord, by our Honorable Division Bench, Calcutta High Court. Because, Milord, yesterday, the reference of Justice Sain's judgment was given to you. Therein, Nanuram was mentioned, that on the basis of Nanuram, Milord, the meaning of the word consortium was expanded. Your Lordship, Milord, I'm sorry, Milord, I have 2 copies. One is missing. Your Lordship will kindly take my copy. This is, Milord, Honorable Justice Sonji Banerjee's Division Bench's order. Milord, pages 1 to 4, my lord, I'll just read and just, my lord, hand it over to your lordship. Mandira Ash. The principal legal issue that has arisen herein is whether, in the light of a recent Supreme Court judgment reported in 2018 SCC online, so and so, Magma versus Nanu Ram, it is permissible to award amounts to relatives other than the spouse under the head of loss of consortium. Notwithstanding the constitutional bench judgment reported in so and so of Pranay Sethi. In Nanu Ram, the judgment in Pranay Sethi was noticed at paragraph 10. However, an additional amount that was granted on account of loss of estate was not interfered in Nanu Ram by expressly referring to the authority of the Supreme Court under Article 142. While dealing with the head of loss of consortium and referring to Pranay Sethi, in such context, Nanu Ram observed. Observation of Nanu Ram is quoted. The Motor Vehicle Act is a beneficial legislation. Nanu Ram says, is a beneficial legislation aimed at providing relief to the victims or their families in cases of genuine claims. In case where a parent has lost their minor child or unmarried son or daughter, the parents are entitled to be awarded loss of consortium under the head of filial consortium. It says parents are entitled to have filial consortium. Parental consortium is awarded to children who lose their parents in motor vehicle accidents under the Act. A few high courts have awarded compensation on this count. However, there was no clarity with respect to the principles on which compensation could be awarded on loss of filial consortium. The amount of compensation to be awarded as consortium will be governed by the principles of awarding compensation under loss of consortium as laid down in Pranay Sethi's case. In the present case, in the Nanu Ram's case, we deem it appropriate to award the father and sister of the deceased an amount of rupees 40,000 each for loss of filial consortium. This is what the finding of the Nanu Ram was. It has been quoted by the Honorable Division Bench of our High Court. Then, my lord, how it has been dealt with. What is evident from the above is that the law relating to loss of consortium has been left untouched and Pranay Sethi had been set to rule the field. However, filial consortium in that case was awarded under Article 142. Under Nanu Ram, it was awarded under Article 142 of the Constitution, and such part of the order in Nanu Ram cannot be regarded as the law laid down by the Supreme Court under Article 141 of the Constitution. There is good reason for taking this view. In a judgment reported in so and so, Rajesh versus Rajbir, it was referred in Pranay Sethi. I had pointed it out. Yes. Rajesh. In the judgment reported in Rajesh, reported in Rajesh versus Rajbir, loss of consortium was awarded to the extent of rupees 1 lakh, and loss of care and guidance of minor children was also taken as a head, and further 1 lakh was granted. Paragraph 52 of the judgment in Pranay Sethi, rendered by a constitutional bench of 5 judges, referred to the 3-judge bench of Rajesh and observed that there was no head relating to loss of care for minor children. Earlier, paragraph 46, I read out paragraph 46 of Pranay Sethi, quoted with approval of the meaning of the consortium. I had
acts in dispute. The fact in issue before Justice Banerjee
Lordship
was death of the children of the parents.
No. Milord, the consortium. Milord,
what was the issue before the division bench? Death of the children of the claimant,
Milord,
or the death of any other?
Issue was whether this consortium can be expanded and save and accept the spouse can be given to anybody else or not. It could be anybody. Father, mother, sister, children.
Who was the victim in that particular?
In this case,
that particular Justice Banerjee.
Major, not minor.
No, injured case or this?
No, this is the death case, of course. On death
case of?
No, death case, I'll indicate to you, Lord.
Clements? What was the relation between the victim?
I'll tell your lordship. I'll tell your lordship. Milord, I'll indicate to that, Milord. But Milord, the principle is whether consortium meaning can be expanded.
Yes.
Milord, then
okay, which paragraph of this thing, this Nanu's case, that is the observation is made by the Honorable Supreme Court. Which paragraph?
Milord, paragraph 10.
Paragraph 10.
Lordship. Starting with the word, the Motor Vehicle Act is a beneficial legislation. My lord has got the Nanu Ram with my lord?
Yes.
My lord, the paragraph 10 has been
10.
quoted starting with the word, the Motor Vehicle Act is a beneficial legislation.
It's not telling with you.
My lord, maybe my lord, the other different journals, my lord, it may.
It is not telling. Okay, just a minute.
Lordship.
The right to consortium would include the company care, this one.
My lord is going through Nanura.
Oh, right. The
Yes,
motor
the motor vehicle act. Yes, my lord. It
is a beneficial
Lordship,
legislation
Lordship,
aimed at
Lordship.
providing relief to the victims
Lordship.
of their families.
And my lord, this quotation here ends at rupees 40,000 each for loss of filial consortium. So this has been quoted.
Okay.
Lordship. And then the Honorable Division Bench, my lord, quoted paragraph 52 of Pranay Sethi. My lord, as far as conventional heads are concerned, my lord, I had read out that paragraph. As far as conventional heads are concerned, my lord.
Give the decision, the unreported decision.
Yes, my lord, I'm giving it to you. And then, my lord, it says, on a conjoint reading of paragraph 46 and 52 of Pranay Sethi, we read out, my lord, it is evident that the head loss of consortium is confined only to the spouse. In Nanu Ram, the two-judge bench referred to other forms of consortium, including parental and filial consortium, in addition to spousal consortium, but accepted that the amount of compensation to be awarded as consortium will be governed by the principles as laid down in the case of Pranay Sethi. Nanu Ram even went on to say that it would be governed by Pranay Sethi, but granted extra. The additional quantum on account of filial consortium and love and affection as awarded in Nanu Ram has perforce to be seen to have been allowed in exercise of the authority under Article 142 of the Constitution, as such award would otherwise clearly fall foul of the dictum in the constitutional bench judgment of Pranay Sethi. As a consequence, the prayer made on behalf of the claimants of granting without additional compensation on the ground of this consortium is not allowed. This is what, my lord, for my lord's consideration. My lord, so kindly pardon me, my lord, I've just given the note. Mandira.
That is Justice Sanjeev Banerjee, Justice Dipankar Datta's judgment.
My lord, I'm giving. Mandira Ash নামটা লিখে নাও, Justice Sanjeev Banerjee, ব্যাস ওটাই। 2017 না 18 2018 বা 19 প্রাণে সেঠির পরে My lord, Justice Dipankar Datta দুটো একসঙ্গে নাও না, একদম আমি আবার বাঞ্চটা মিস করে গেছি। Lord, Justice Dipankar Datta's judgment, my lord. Sona Singh. My lord, Justice Datta, my lord, sitting with my lord, Honorable Justice, my lord, Pratik Prakash Banerjee, as his late lordship then was. My lord, along with others, my lord, it deals with consortium also. It deals with Nanu Ram specifically. Paragraph 29 onwards, my lord. Lastly, we refer to the contentions of the learned counsel for the claimants, cross-objectors, on the issue that an additional amount towards loss of consortium should have been awarded for the claimant mother of the victim as loss of filial consortium due to the loss of her son. The award of an amount towards loss of consortium has been settled by Honorable Supreme Court in the case of Pranay Sethi, wherein the Honorable Supreme Court, after visiting its own precedents, held the following. My lord, this paragraph 61 has been quoted. Therefore, we think it seemly to fix reasonable sums. It seems to us that reasonable figure on conventional heads, namely loss of estate, loss of consortium, and funeral expenses, should be rupees 15,000, 40,000, and 15,000 respectively. The principle of revisiting the said heads is an acceptable principle. So, my lord, this has been quoted, paragraph 61 of Pranay Sethi, my lord, 61.8. The Honorable Apex Court even noted that in different cases, different amounts have been granted. For example, a sum of 1 lakh was granted towards compensation to children for loss of love and affection in the case of Rajesh versus Rajbir. The Honorable Supreme Court in Pranay Sethi held as follows. Paragraph 54 quoted. Again, Pranay Sethi, paragraph 54 quoted, my lord, starting with the word as far as the conventional heads are concerned, with Honorable Justice Banerjee was also kind enough to quote. And then, my lord, the finding in paragraph 30, it is therefore clear that the amount towards loss of estate, loss of consortium, and funeral expenses has already been quantified by the Honorable Supreme Court at 15, 40, and 15, respectively. Therefore, My lord, this is the observation of.
With regard to Nanuram's case, what is the observation of Justice Datta?
My lord, this next paragraph. My lord, the observation of Justice Datta here is paragraph 30. It is therefore clear that the amount towards loss of estate, consortium, and funeral have already been quantified by the Honorable Supreme Court at 15, 40, and 15 respectively. Therefore, no further amount shall be granted towards loss of consortium beyond the figure provided above. Once the Constitution Bench judgment of the Apex Court is cited before us, which we must respectfully apply, we do not have the luxury of subscribing to a different view, as it is a law laid down within the meaning of Article 141 of the Constitution of India, even if we thought differently, which we do not. Next paragraph, Nanuram, paragraph 31. The learned counsel for the claimants cross objectors brought to our notice a judgment passed by a division bench of Honorable Supreme Court in the case of Nanuram, whereby an amount of 40,000 each for loss of filial consortium was awarded to father and sister of the deceased. In that case, in Nanuram's case, our difficulty in relying upon the aforesaid judgment is that even though a reference of the decision of a larger bench, Pranay was made, the law regarding payment of consortium as laid down therein was departed from in Nanuram's case. In view of the position of law and the provisions of Article 141 of the Constitution of India, however, Nanuram is at best a decision under 142, Article 142 of the Constitution, to do complete justice to the parties in the facts and circumstances of that case, which power we do not have. As a court of appeal under Section 173 of the 1988 Act, we continue to be bound by Pranay Sethi. Even otherwise, the decision in Nanuram does not apply to the present case. My lord, it says that the victim was, my lord, unmarried sister. The facts were a little different. In that case, it was given to mother and
For Nanuram's case, father and the sister.
father and sister. My lord, in this case, father and sisters were not there. Maybe the children were there.
Children, wife, and the mother.
Lordship. So, my lord, that particular fact is different. But otherwise, whether the term consortium can be expanded or not, my lord, that is very clear. My lord, your lordship will kindly pardon me, my lord, it was my copy. I have referred to the paragraph here.
We give those two copies.
My lord,
This is
these two.
Justice Banerjee's and the Justice Datta.
Justice Datta. My lord, in addition to that, my lord, I'll just give, my lord, one judgment, my lord, of Honorable Justice. My lord, there are, my lord, as I said yesterday, every single case of this High Court till date, my lord, has been, my lord, 7 except, my lord, those is straight 2-3 judgments, my lord, has confined the consortium, my lord, to spousal consortium, my lord, till my lord, Honorable Justice Honorable Mondepa, that is the last very judgment of that.
Justice Sen's judgment did not consider the division bench judgment. So far, Justice Sen's judgment is concerned.
Yes,
the
it was not
division
shown. It was not shown to him.
No, from the insurance company side also it was not.
It was not shown, my lord. So he simply went on the basis of Nanuram. Nanuram was shown. Nanuram was deferred. Nanuram was taken note of by our division bench. My lord, that was not shown, my lord, to his lordship. And my lord, one judgment, my lord, I'll just indicate to your lordship. What up? Just give us what a charge. Give us what next survey. It a copy naina. Asche. My lord, I will not read, my lord. If for my lord satisfaction, paragraph 10, my lord, this takes note of subsequent judgments of Supreme Court after Nanuram, which had also granted, my lord, this consortium. My lord, as I said, my lord, there are now a number of judgments coming up in Supreme Court. Supreme Court, in its wisdom, my lord, in one particular case or other particular says, we will grant it to the children, we will grant it to the mother, we will grant it for 40,000.
So all are under 142.
That's what I say, my lord. Your
That's the
lordship,
thing.
my lord, your lordship. Yes, so that's what, my lord, the Honorable Division Bench says, my lord. Because if a particular court differs from a constitutional bench, after taking note of that, my lord, what is the outcome of that, my lord? It is for my lord to decide. My lord, paragraph 10.5 onwards.
So at best it can be 142.
At best it can be 142 because, my lord, Pranay Sethi is absolutely clear. It has dealt, my lord, the English meaning of the word. I cannot say 5 judges bench sitting together, taking note of a 3 judges bench definition, 8 honorable judges when sit together, my lord, and decide the meaning of English meaning of the word consortium, and they come to a finding that the consortium means spousal consortium only. Then, my lord, another honorable division bench sitting, my lord, differently, or a 3 judges bench says that no, we feel consortium means this. We feel that the meaning of the word consortium can be expanded. But, my lord, whether that would, my lord, overturn the 5 judges bench because they are word specific.
For Black's Law Dictionary,
Lordship.
what is the
Milord, Milord, my English is not that good. When
Black's
5
Law-
judges of Supreme Court are sitting and deciding the English meaning of one particular word, Milord, I am in no position to go over and above that. Because they have dealt with that, they have quoted the word, they have said what it does mean. Milord, today here, Milord, why shall I, Milord, when 2 honorable division benches of Calcutta High Court have conferred, and Milord, they have stated that yes, we go by that particular meaning. Milord, who am I, Milord, to question the meaning of that particular word today? If at all, Milord, anybody differs with that meaning,
Question
if
is
Lordship.
subsequent judgment considered what is the meaning of consortium as per Black's Law Dictionary? How does the English courts deal with this?
Milord, then your
What is
Lordship,
what consortium?
will deal with that, Milord, if my Lord thinks.
No, what is this meaning of consortium?
Milord, the meaning of consortium is given in that definition, Milord, that Rajesh and Ratpir, which has been quoted by the 5 constitutional bench.
Well, that Black's Law Dictionary was considered.
Milord, Black's Law Dictionary is not noted over there. That is from Black's Law Dictionary, but the meaning of the word, their lordships sitting together, they have quoted. What does the word consortium mean? And it should be confined to the spousal consortium only. 52, 54 deals with that only. It quotes that. So, Milord, why shall I today say that no, or for that matter, for anybody else, Milord, say that no, I feel that I would add A, B, and C or 1, 2, and 3 to the meaning what has been decided by the Honorable Supreme Court. This is number 1. Milord, Supreme Court today, in its wisdom, Milord, under Article 142 can pass any judgment. But whether High Court has got that power or that right, Milord, to expand the meaning of what 5 judges say that no, I go beyond that. Milord, I respectfully, Milord, put this before your Lordship, Milord. 142 Supreme Court say anything, Milord, all judges are equal. They say that no, 5 judges bench said that. Milord, we will not go by that. We will think this way. Milord, this judicial, Milord, Milord, this judicial discipline, Milord, it itself has been dealt with this constitutional bench judgment of 5 judges, Penal City, paragraph 16 onwards. Milord, their lordships have devoted 7-8 paragraphs that why, when a bench of larger strength decides one particular issue, any bench of lesser strength, Milord, should not deviate from that. My Lord has got that Penal City, Milord, I had given to your Lordship.
Yes.
Paragraph 16 onwards, Milord, this deals with binding precedent. Paragraph 160, my Lord kindly comes to Milord. Penal City, paragraph 16. Penal City is, my Lord, is having that. My Lord has got it, Milord. May I give my copy of this? Penal City, my Lord. Today I gave to your Lordship. But this is National Insurance versus Penal City. Milord, this.
Yes, this is Pranay Shetty.
I'm grateful to your Lordship. Milord, may I invite my Lord, Milord, to paragraph 1616 at page number 7. It is at the bottom of the page, Milord. My Lord is there, Milord? 16. Milord, presently we may refer to certain decisions which deal with the concept of binding precedent. Milord, why their Lordship, Milord, had to go to this? Because of, Milord, various confusions, Milord, of different honorable Supreme Court judgments, Milord, which were deciding one particular issue of quantification of the award differently. So, Milord, this is why when this particular judgment came out, Milord, their Lordships were very clear that this should be followed, and Milord, this binding precedent concept, Milord, was dealt with. Milord, 17, in state of Bihar versus so and so, it has quoted, an earlier decision may seem to be incorrect to a bench of a coordinate jurisdiction, considering the question later, on the ground that a possible aspect of the matter was not considered or not raised before the court, or more aspects should have been gone into by the court, deciding the matter earlier. But it would not be a reason to say that the decision was rendered per incurium and liable to be ignored. The earlier judgment may seem to be not correct, yet it will have the binding effect on the later bench of the coordinate jurisdiction. Milord, the court has further ruled, subparagraph 10. Milord, I'm on the next page, Milord, at the top. Easy course of saying that earlier decision was rendered per incuriam is not permissible, and the matter will have to be resolved only in two ways, either to follow the earlier decision or refer the matter to a larger bench to examine the issue in case it is felt that earlier decision is not correct on merits. Milord, 18 deals with that. 19 also deals with that. In this regard, Milord, 19, we may refer to a passage of so and so. 19, Milord, subparagraph 11. May I read, Milord?
Yes, para 11.
Milord, I had started, Milord, from paragraph 16, 17, that was subparagraph 10, Milord 18, and then 19. 19 has, Milord, subparagraph 11. Then, Milord, paragraph 20, 21. Milord, each one is dealing with the binding precedent. 22, subparagraph 22. Milord, paragraph 22, Milord, Chandra Prakash's judgment. A constitutional bench, Milord, paragraph 22, if you lordship kindly see, a constitutional bench deals with the concept of precedent, states, subparagraph 22, the doctrine of binding precedent is of utmost importance in the administration of our judicial system. It promotes certainty and consistency in judicial decisions. Judicial consistency promotes confidence in the system. Therefore, there is this need for consistency in the enunciation of legal principles in the decision of this court. It is in the above context, this court, in the case of Raghuveer Singh, held that a pronouncement of law by a division bench of this court is binding on a division bench of the same or smaller number of judges. My lord, we are today dealing with a judgment of 5 judges bench, who specifically deals with the issue. And then, my lord, in order to avoid confusion, my lord, their lordships went on to the extent of, my lord, giving the principles of binding precedent. My lord, 23, 24, 25 is the culmination, my lord. It is stated what has been expressed in Raghuveer Singh. It is Chief Justice Pathak as follows. We are of opinion that a pronouncement by a division bench of this court is binding on a division bench of the same or a smaller number of judges, and in order that such decision be binding, it is not necessary that it should be a decision rendered by a full court or a constitutional bench of the court. Milord, it has, I'm sorry.
Yes.
Milord, 16 to 25 only deals with the binding precedent of the judgment. Milord, and the judgment, Milord, Pranaseti is a constitutional bench judgment which specifically, very clearly deals with that particular issue. And now deviation by subsequent courts, Milord, or by subsequent benches, which are not of that strength, Milord, is not permissible. This is what has been decided by our 2 honorable division benches. Milord, Supreme Court, in my humble submission, can write, Milord, but whether today the honorable high courts, Milord, can deviate,
Follow the subsequent deviation or the pronouncement.
or the Pranaseti.
Well, what this court should
What
follow.
this court should. Milord, as far as deviation part is concerned, Milord, very surprisingly.
Suppose any matter goes again to Supreme Court,
Yes.
and the Honorable Supreme Court in the 2 judges considers pronouncement and thinks fit to deviate.
Lordship.
That power is there.
That power is
But
there.
whether this court has the power.
Lordship. And Milord, difficulty is, Milord, I'll just indicate this judgment. This deviates from Pranaseti. It does not give any money to consortium. Or under the head of general damages, no money is given. Milord, shall I take advantage of this? This is other Supreme Court. Milord, what I say, that the deviations are there. Deviations are to the extreme. No compensation granted under the general damages. Milord, I'll take your lordship, Milord, to the calculation part. Paragraph 15. Eta ache tomar Prem Lal Anand versus Narendra Kumar. Supreme Court, your lordship will kindly come to paragraph 15, Milord. Another aspect to be considered is the grant of future prospect as per Pranaseti. It provides that if the deceased was self-employed or on a fixed salary, considering the age of the deceased, certain
No, in
percentage.
the instant case, the dispute is with regard to the grant of no, there is no dispute with regard to the grant of future prospect.
No, nothing.
Now, on which issue you have raised the dispute in this appeal?
Milord, in this appeal, Milord, what, Milord, my principal, principal counter chilo. Milord, it was on quantum of income of compensation.
Quantum on what hates?
Quantum of income of a minor.
Yes, that is quantum on the income of a minor.
And second
That is there, and the other is This consortium.
And general collective head of general damages, which includes consortium. Yes, consortium. My lord, on consortium, my lord asked me, my lord, to submit. So my lord, my argument is confined only on consortium. Whether the meaning of consortium can be expanded over and above the spousal consortium or not. My lord, my entire argument is sticking to that.
For that, you have relied upon this decision, that is Pranay Shetty and the division bench of our court.
Lordship. And my lord, I am also indicating, my lord, when the court's honorable Supreme Court is deviating, and my lord is trying to take advantage of that deviation, my lord, in this deviation, my lord, paragraph 15, I have showed to your lordship, this Prem Lal Anand, paragraph 15, Pranay Shetty was taken note of, and then lordship will kindly come to my lord, paragraph 16.
Yes.
Calculation, your lordship will kindly say what Supreme Court gives. 75,000, which includes future prospect. This is a monthly income, my lord, or annual income. 15 multiplier. Hence, the claimant would be entitled to a sum of rupees this and this instead of 1,01,000. No, my lord, no head of general damages at all. Taking note of Pranay Shetty, did not grant anything, forget about consortium, did not grant, my lord, the funeral expenses, did not grant loss of estate. My lord, I asked this question to myself, do I take it to be a good judgment and, my lord, trouble your lordship with this? Or should I not? I do not. My lord, I decide that I will not trouble your lordship with these kind of stray judgments when, my lord, your lordship's time would be wasted. Because when Pranay Shetty is there, I concede to Pranay Shetty. I say that yes, money be given. I will not trouble your lordship, but this is subsequent to Pranay Shetty. It has taken note of Pranay Shetty. It says, my lord, upon calculation, nothing to be granted under general damages. So your lordship will kindly take note of this and will not pass judgment. My lord, I consciously, I do not trouble your lordship with these kind of, there are other judgments also. It is not, my lord, one single stray judgment. On this particular issue, there are other judgments which have deviated from Pranay Shetty and have given lesser amount or no amount. My lord, there are judgments where no future prospect has been granted. Do I trouble your lordship with those? No, I say when I accept Pranay Shetty,
to accept the reasons on what grounds.
Lordship.
Reasons are to be accepted.
Lordship, my lord, but my lord, on principle, when the quantification has been made and 5 judges say that no, for this particular age group, this should be the future prospect. For this particular income group, this should be not the multiplier. So, my lord, when I take that Pranay Shetty, my lord, I am taking it as a whole in totality. It is not that the part which is to my advantage of that 5 judges bench, I will take that part. And then another division bench comes up, which is to my advantage and which deviates from this constitutional bench. I'll say up to this is okay. And now I will take advantage of this. I will leave the rest aside. I cannot do this. My lord, this is what, my lord, I humbly wanted to submit. Supreme Court can do, my lord, at the cost of repetition, I say. But whether High Court, my lord, taking note of, my lord, our division. My lord, today what my lord has? Today my lord has, my lord, 1 5 judges bench against 2 3 judges bench of Supreme Court. My lord today has 2 division bench judgments of this honorable court, which took note of the other cases. And my lord has 1 or 2 or 3 or 4 or 5, my lord, single bench judgments of this honorable court. So my lord has, my lord, the option whether to, my lord, accept 5 judges with the division bench of Calcutta High Court or take note of, my lord, 2 or 3 judges and, my lord, the single bench judgments of this. Whereas all honorable single benches, my lord, have, save and except, my lord, those 2 wherein the proper, my lord, this court was not assisted properly. My lord, other than these stray judgments, my lord, there is none which say that we will not follow Pranay Shetty, or rather we would grant excess compensation over and above the spousal compensation. My lord, I was indicating to your lordship, my lord, one judgment of honor, my lord, this would be the last one, my lord, I won't trouble your lordship, because if I start showing, my lord, every single judgment I have to show to your lordship, all judgments which have been passed by this honorable court. This judgment, my lord, had taken note of, my lord, Pranay Shetty, Nanuram, at least 3, 4, 5 other subsequent judgments of Supreme Court. And then, my lord, came to finding that no, Pranay Shetty is the correct law. And, my lord, this court should not exceed. My lord, because what is happening? This particular point is being raised in all courts. My lord, at least 7, 8 courts, this point has been raised. My lord, my learned friend is trying his luck in every single court whenever the determination changes. Everywhere, my lord, he loses. And again, my lord, today, my lord has got this determination. Again, my lord, this lottery is being played. So, my lord, your lordship will kindly come, my lord, to paragraph 10.5.
This way telling that
Lordship.
this court's power is limited.
My lord.
Even this matter, if goes to the Honorable Supreme Court,
Let Supreme Court decide.
Honorable Supreme Court may under 142.
Yes. And if, my lord, that also, my lord, under binding precedent, my lord, paragraph 16 to 25, Supreme Court said that if you differ, if you say that the earlier judgment of a even of the similar strength bench was not to your liking or was not correct, refer it for a larger bench. In our case, it is 5 judges, what is
Only the factual aspects can be
Lordship,
distinguished,
Lordship,
not
Milord,
the question of law.
my lord. So, Milord, in factual aspect, Milord, it is very clear whether consortium is confined to spousal consortium or not. Milord, paragraph 10.5, Milord, of Justice Pattanak's judgment, if your lordship kindly comes to Milord, if I can invite my lord, 10.5, Milord, is at page number 10. Is my lord, Milord, there? 10, page number 10.
This is with regard to parental consortium,
Lordship, whether the meaning of the term Milord consortium can be expanded or not.
demise of his father.
Lordship. Milord, whatever the facts are there, whether other than a spouse it can be granted or not. It can be children, it can be mother, parents, Milord, of brothers, sisters.
The statute is concerned, you see, consortium is confined to only spouse.
I'm extremely grateful to your lordship.
That
My
is
lord.
what the
Yes,
judges bench has held.
lordship,
Now,
lordship,
thereafter, this filial, this
and parental,
consortium,
lordship.
this concept, okay, it
First time appeared in Nanuram.
new to us, all of
Lordship,
us.
lordship,
So
lordship.
that is what we are
And
considering.
Milord, it came from Nanuram,
Yes, that is what I am telling you.
lordship. And
that is
Milord,
the new
different,
concept.
grateful to your lordship. Milord, different honorable judges, Milord.
So we have to explore that concept also in near future.
Milord, if Supreme Court says, Milord, if any bench of the strength of Pranay Sethi or the larger says that you give, we give.
That is
Milord,
why I was asking, what is the definition of consortium as per Black's Law Dictionary?
Milord, I'll come back to your lordship with that. But Milord, whatever it is, when the constitutional
Anyway,
bench is there, so
the
Milord,
scope is limited.
the scope is
The
limited.
statute as well as the 5 judges bench.
5 judges bench, Milord. Milord, 10.5, Milord, I was inviting your lordship to at page number 10.
Actually, you see, earlier also no award, no damages was granted on the ground of this other consortium, save and except the spout. That statute was followed.
Milord, the statute, Milord, is.
Statute was followed.
I'm extremely grateful. My lord
But even
remembers,
earlier
Milord. Milord, I'm thankful to your lordship.
After this new concept, we are also exploring the possibility if there is any scope.
Milord, earlier even this future prospect was not there. Sarla Verma, prior to Sarla Verma is 2008. Prior to Sarla Verma, Milord, in this entire motor vehicle sector, Milord, whatever little I have seen, Milord, there were only 3 judgments out of thousands and thousands, which had dealt with the issue of future prospect. Sarla Verma for the first time said that no, we will give some more. We will grant future prospect. From there, Milord, this concept of future prospect, Milord, Sarla Verma used the term rule of thumb. So, Milord, from there, this future prospect, Milord, was given as an additional benefit to the claimants. And since it was a beneficial legislation, Milord, Supreme Court said, okay, fine. When you give something extra, you give it. This was further, Milord, fortified by Pranay Sethi, which made the specific chart that for this, give this amount of future prospect, for this amount of, no dispute, Milord. Supreme Court said, constitutional bench said, Milord, no dispute from none quarters. The money is being paid. But now, Milord, when other aspects of Pranay Sethi, one starts challenging, they accept future prospect, they accept multiplier, they accept, Milord, personal deduction because it is to the benefit of the claimant. Fine, no dispute. But once, Milord, any other division bench or 3 judges bench says that no, I'm granting something extra, you latch on to that. And you say, now I forget Pranay Sethi. Milord, this is where I join issues. 75%, 80%, or 90% of the judgment is in your favor. Insurers are giving that favor. I would not say favor, Milord, it is binding upon them. They are complying with the order. 10%, you say that no, I get some extra advantage in other judgment. So you say, now I leave Pranay Sethi. I'll get 90% advantage from Pranay Sethi, and from that 10% consortium, some other courts are granting more. So let me latch on to that. This is where, Milord, I join issues, Milord. This is where, Milord, it troubles me. Then you leave the other part of Pranay Sethi, then you accept the Supreme Court Prem Lal, which does not give conventional heads 1 paisa. If you are deviating, then deviate, then we will also argue. Then we also accept that in the judgments where the future prospect was not granted, it deviates from Pranay Sethi. Don't take future prospect. You don't take that. You take the entirety of Pranay Sethi, save and accept anything extra if you're getting from other judgment. This is, Milord, not permissible when Supreme Court is very clear that, Milord, the binding precedence principle is there. And that has been dealt with, Milord, by their lordship, the constitutional bench. And this is what, Milord, the single bench judgment of Justice Pattanak, what I had handed over to your lordship, Milord. I was inviting my lord to paragraph 10.5.
Yes,
If my lord
I've
is
gone
there.
through that.
So it again deals with various other judgments. After this also, another a very big judgment. It was again raised before Justice Subendu Samanto. I am not troubling your lordship with those. The same was it before Justice Honorable Justice Ananya Bandyopadhyay. I am not troubling your lordship with those. Every single court, this was tried. The luck was tried. They failed. And again today, my lord is being troubled with this.
Only Justice Sen's court accepted this contention.
But because the other judgments division bench was not shown to him. One should come to your lordship with clean hands. If I am giving one dissenting judgment of planacity, I should also indicate to your lordship, it is within my knowledge that after this, the division bench judgment was there. After planacity or after Nanu Ram, I should have indicated to your lordship. I don't do that. That is where the trouble starts. If you are entitled, you take it. Nobody is disputing that. But if you are not entitled, kindly not mislead the court. On this particular issue, this was my submission. One judgment that whether the larger bench judgment would prevail or the bench of a smaller would prevail. This another court. Shall I trouble your lordship if my lord so is so, it's another.
Pranay deals with all these things.
Pranay deals with that. This in subsequent to that, a larger bench judgment would always prevail.
This is what Pranay has discussed.
Pranay has discussed. So I am not troubling your lordship with this, Yes. So I conclude my submissions not only on the point of this, whether the meaning of the term consortium can be expanded or not, Extremely grateful to your lordship.
Yes, so I can conclude the hearing today.
No, my lord.
So what do you want to
Also,
submit?
my
Anything
lord,
else?
Reply.
Yes, you reply.
My lord, today is fixed for my lord handing over the decision, not for argument.
Argument on the decision.
Since my learned friend makes the argument at length, I shall argue the at length.
Okay, Monday.
Not Monday, today. My lord, your lordship kindly allow, I will take my lord 15 or 20
Okay,
minutes.
2 p.m. then.
No, my lord, I'm finishing it, my lord, mean the short. Now, my lord, here, kindly consider. My lord, this appeal involves, my lord, the insurance appeal involves, my lord, the two issues. One is the income of a minor, whether it can be, my lord, the 30,000 or, my lord, the 5,000 per month. My lord, in this regard, my lord, yesterday, I cited, my lord, the judgments of, my lord, two decisions where the Honorable Apex Court very recently says that the income of 5,000, but the accident took place, my lord, in my case, the accident took place in the year 2021. 5,000 may be reasonable, acceptable, and rational. My lord, give acceptable. Now, to that extent, I place, my lord, the judgment. Judgment is, my lord.
Yes, you have placed yesterday.
Now, my lord, regarding the, my lord, second issue, is a, my lord, the filial concept. My lord, your lordship, my lord, yesterday, my lord, sought to know whether the Pranay case deals with a case of a minor death regarding the consideration for consultorium. Answer is no. My submission is also, my lord, the same thing. My lord, the Pranay case, my lord, that is the binding, my lord, the precedent. My lord, the Apex Court judgment consisting of the constitutional bench, 5 judges bench, that was the guidelines, my lord, the 5 were, my lord, decided by the constitutional bench. Where the spousal consultorium has been decided, but the filial consultorium, loss of a son, loss of a daughter, to the manner the affection, love and affection to the parents, filial consideration, the court, whether court can grant or not. That, my lord, the considerable point, my lord, that your lordship allow, my lord, us, my lord, to make citations. My learned friends, my lord, relies on the, my lord, the different, my lord, the honorable judges, my lord, decision. One is, my lord, the Shondi Banerjee, as his lordship then was. Then, my lord, the Honorable Bandyopadhyay, and the Honorable Justice, my lord, the Vivash Bhattacharya. Now, my lord, I have also, my lord, relied yesterday only the Honorable Justice, my lord, Partha Sarathy Sen. Where, my lord, Partha Sarathy Sen, the Honorable Justice Partha Sarathy Sen was expressed, my lord, the Philalian consortium, what is the meaning? Not this spousal consortium, Philalian consortium. Now, my lord, today I have brought, my lord, the another, my lord, the two decisions of our High Court, where the Honorable Justice Vivash Ranjan De granted, my lord, Philalian consortium. I will place, my lord. Your lordship kindly
Was
take
all the relevant decision considered by Justice Day?
Vivash Ranjan De.
Yes, yes. Whether all the other the judgments of Justice Banerjee and
Yes,
Justice.
yes, your lordship kindly see. My lord,
This is
the-
what
this is
compilation.
My lord, in this compilation, I have tagged, my lord.
All the others, this Pranay Shetty and all, everything.
No. The five judges, the five judgments of the Honorable Apex Court. After the Pranay Shetty was pronounced, your lordship kindly see the first, the Kurban answer. Your lordship kindly first page.
Yes.
Page 1 to 5.
So come to the decision of Justice Day. Which page?
Justice Day. Your lordship kindly turn to, my lord, page 70 to 81. This is not a case while my learned friend says that this Nanuram's case is a passed by the Honorable Apex Court. Honorable, your lordship kindly turn to page 70. The decision of the Honorable Justice Vivash Ranjan De.
Yes.
It was decided on, my lord, September 14, 2022. That is long after, my lord, the November 2017. That is the pronunciation.
নামটা বলবে?
Future Insurance Company versus Shopna Course. Now, my lord, your lordship kindly turn to, my lord, page 74 of my copy, paragraph 9.
Yes.
Now, my lord, your lordship kindly turn to, my lord, page 80. My lord, this is a case where the, my lord, this is for the major, not minor. But, my lord, here the claimants are the wife and the, my lord, the sons and daughters. My lord, your lordship kindly turn to page 80 of my computation. Calculation portion. my lord, in the middle portion, loss of consortium, bracket, spousal, and parental. That is 80,000 was granted. Now, thereafter, loss of estate 15,000, funeral expenses. Okay. So, total, my lord, it comes, my lord, the 26 lakhs 91,636. My lord, tribunal awarded 15 lakh something financial amount. All is directed to the. Now, my lord, next case is also the another decision of Divashanjan. That was also decided, my lord, on
Page 82.
page 82. That was also decided on September 15, 2022. That is the, my lord, 5 years after passing the prononciation. And also these judgments, my lord, deal with the pronunciation.
ভাই একটু নাম বলে দাও তো।
And Debojyoti Dutta Bhasu. My lord, your lordship kindly come to, I'm not taking my lord much time. Your lordship kindly turn to my lord page 92.
Yes,
Loss of
yes, Mr. Bonik, I have a division bench at 12:30
No, my lord,
and now I have some other original side matter. So you continue at 2 or come on Monday?
No, my lord. Your lord, I'm finished. I'll take.
No, see,
2 minutes. 2 minutes. Only
you
get.
continue on Monday.
My lord, 2
Why,
minutes.
why
My
there
lord,
is so much hurry?
I finish, my lord. On Monday, my lord, I do my lord another case. But
So
2
come at
minutes.
2 p.m.
Kindly grant 2 minutes, my lord. My lord, this is my lord the judgments of my lord the Divashanjan Day. That was my lord. See, I have exactly this is my lord the judgments of my lord the Honorable Justice Divashanjan Day as page 70, 82, and my lord two judgment of Divashanjan Day and one judgment is Madhuvi Das. That was the Honorable Justice Partho Sarathy Sen. On page 95 to
That you have relied yesterday. You have relied that.
Yes, sir.
Yes.
Now, my lord, your lordship, kindly turn to, my lord, the first portion of my notes. The Kurban answering. My lord, yesterday I relied on.
Yes, yes, yes.
This is death of a minor. Where the, my lord, the funerary and consortium 40,000 to each parents was granted. Then, my lord, your lordship, kindly see the Nanuram. Nanuram, according to my learned friend, says that one of the judge of this honorable court as lordship was said it was passed, my lord, under Article 140. I don't know, my lord, I with greatest respect how my lord says that this order was passed under Article 142. It was never, my lord. I have gone through many, my lord, judgments where, my lord, the Supreme Court says this judgment was passed under Article 142. But in Nanuram's case, it was not said. But his lordship, my lord, at his discretion, said it was a case, my lord, under Article 142. Then, my lord, your lordship kindly turn.
Yes, anyway,
You
regarding
lordship-
judgments, I shall consider. If you want to argue, you either
No,
come on.
I'll finish.
No, decisions you have already given, I shall consider. But
Yes. And then, my lord, another decision which was decided on 2022, Harpreet Cow, where the
you have given the compilation, I shall
Yes.
consider that.
Harpreet Cow and my lord, then my lord, the Anjali and others. My lord, the Anjali and others. Your lordship kindly see the notes of citation. My lord,
Yes, is there.
Anjali and others, and then my lord, the 5 is New India Assurance Company versus Somuti. It was decided on 2020.
Okay,
The
okay.
Honorable Appeals
The
Court.
judgments will have to be considered, okay?
The judgments,
If you want to-
whoever says that
If you
it
want
was-
to, if you want to cite these judgments, you please come on Monday.
No, my lord, these I am handing over, your lordship pass the
Okay.
My lord, kindly think, my lord, a father or mother lost his, my lord, son or daughter.
Yes,
My lord,
those
the
will be
court-
considered definitely. All will be
And
considered.
tribunal is not powerless to grant my lord the just compensation as decided,
All
as statute says. Your lordship says, statute says the just compensation. Your lordship, my lord, time and again says what the just compensation the High Court can pass. Your lordship kindly consider if the parents who lost their my lord, the son or daughter, my lord, can they get not be entitled to get the compensation?
that
or-
will be considered. Yes, learned advocates for the parties, heard learned advocates. Hearing is concluded. Let this matter appear for judgment on 21/11/2025.
Obliged to my lord. Extremely grateful.
Yes, call the original side matters. না সময় নেই ক্রিমিনাল দুটোর সময় হবে
My lord, 21/11/2025.
Yes, call the item 4.
Item 2, my lord.
No, appellate side.
Let's. How does not calling original?
Yes,
Item 4. The state here, my lord, for correction, you kindly see paragraph 6 of your lordship order, last order. Paragraph 6 of,
yes.
my lord, there it is written that fake currency, my lord. It is a currency that has been recovered from the existence. No currency, fake currency.
My lord, may I? Oh, yes, bolo. My lord, if they say so, my lord will read my lord's order, my lord. It says that petitioner 2 was allowed. 1, 3 and 4
You
were.
want to bring the case diary again?
My lord, the question is let them file an application because this changes the complexion of the order. If fake currency becomes original currency, then 1, 3 and 4 are to be granted bail. That was the moot issue for which your lordship rejected the bill.
So you can.
Now they want, now after it is rejected, they come up say, no, it is not fake currency, original currency.
Well, no, whatever is the prosecution case that I have stated.
Yes.
Not your contention.
And that is
the prosecution case.
And on the basis of that application
What
was
is the
rejected.
observation?
Let them file an application, my lord.
This is the state. This is the
Learned
submission of the state.
Yes, I am for the state, my lord. Here,
You are for?
I am for the state here.
I am the petitioner.
This is a
And my application got
Okay. We show that the
currency
number of
recovered, my lord. No
fake
fake
currency.
and
So
because
according to you, it's
currency, only currency recovered. My lord.
say so if it is not fake currency, the others will be now liable to be granted bail
so it's better you bring the case diary.
and file an application also.
Okay. Let the case diary be learned advocates for the parties are present. Let the case diary be produced on 14/11/2025.
40.
Well, your lordship has to direct them to file an application if they have to bring the case diary. Because today, my lord, your lordship is reconsidering. This is after 362. Now
Okay,
your lordship has
Let us see the case
that
diary thereafter.
jurisdiction is taken away today.
Okay.
So now, unless they file an application, how are they
No,
going?
correction can be made by the court.
But
which
this
has
is
passed
not
the order.
clerical. This is absolutely on the merits. Your lordship is revisiting the order.
See the case
That was
diary.
not
Okay.
my submission, my lord. That was
Okay. Bring the case diary. Yes, call the original side matters.
You mentioned this.
Can you mention it?
Yes, call the list.
Mention at number 1.
Come at my instance, Lord.
Yes, what was the order passed last occasion?
It's a part hard matter, Lord. Your Lordship fix the date of hearing, Lord. Long date, Lord. Matter happier day after day, Lord. For under the heading hearing, Lord. During the
No,
hearing,
evidence is going on.
no, Lord. Hearing at the time of hearing, Lord. They said, Lord, they have a no witness, Lord. That is the reason, Lord. Your Lordship.
Yes, because it is part hard, it cannot be, evidence is not complete, okay?
Lord, evidence is not complete, Lord. Only one evidence, Lord. It is extra evidence, Lord. Other evidence has been already been complete.
Whatever it
And
is,
Lord,
you see.
and Lord, your Lordship heard the suit.
No, I have not heard the arguments of the suit.
No,
Only the evidence.
Not the argument, but the evidence has been laid. Lord, evidence has been laid by your Lordship.
Yes, yes.
By your Lordship's court.
So had it crossed the evidence stage, I could have retained the
Lord,
matter.
it is a 96 matter. Lord,
Anyway,
99 matter, Lord.
anyway, it can be heard by the regular bench. Yes, take down. Learned advocate for the plaintiff is present.
Fix the matter.
As this
Evidence
matter,
is completed, Lord.
as the matter has not crossed the evidence stage, the matter stands, the part heard is cancelled and the matter stands released from the list. The matter may be placed before the regular bench. Yes, call the next.
At number 2.
My lord, I am appearing here for the plaintiff. Some of the defendants have taken out an application under Order 7, Rule 11.
The application,
They have finished.
application is appearing as a part heard matter.
Yes. For application for taking the plaint of the file, Order 7, Rule 11. They want the stock before the trial.
So I should try your luck before the, take your chance before the regular bench.
No, this Your Lordship has heard Mr. Abhijit Mitro. Your Lordship recollects.
Defendant number 36. We were asking on the points.
Hearing
us.
Defendants have started. One set of defendants have finished.
Take some time. So
No, it should not take much time. Defendant will take about 10, 50, 50 maybe.
yes, you are for the defendant.
No, he's for one of the defendants who's made the application.
My lord, it was my application. My lord would recall Mr. Mitra has concluded the submissions. My lord, Mr. Shirato Mitra had also concluded his submissions.
Yes, I'm not saying I'm submitting. I've concluded my
No, I'm not
submission.
suggesting that.
Anyway, so you make some time when you can argue and complete the arguments.
But he is arguing it.
Yes.
Any day, my lord, fixes the special counsel.
Yes, record an order. Learned advocates for the parties are present. Let this matter appear on 21/11/2025.
My lord, would it be your lordship's
As a part of the matter, my lord.
It is part heard.
would it be your lordship's pleasure to keep it on November 13th, my lord, subject to your lordship's
Actually, I'm keeping this part heard matters on Fridays, so
Friday.
it may not be possible.
You're
on Friday.
not going to make such.
No, no.
Yes,
They are making the submission,
Yes, I'm
not my
keeping it
learned
on
friend.
21st. Okay.
Then, my lord, another date may be given, my lord, for us to reply to whatever submissions.
Yes,
my lord.
yes,
I'm
that-
deeply obliged. I'm deeply
Okay, 21/11.
deeply obliged.
As a chamber application.
No. Simple as a part heard matter.
Ordered matter. Very well. 21st. 21st November.
At number 3.
As part heard matter.
Lordship, I am appearing for the petitioner.
21st November আসবে part heard. Part heard তো হয়ে গেছে, লেখাই আছে, হয়েই আছে।
Yes, you are for the opposite party. Yes, thus this application stands allowed. Let there be an order in terms of prayer A, B, C, D, E, F, and G of the master summons dated 15th day of February 2019. Let the amendment be carried out within 4 weeks from date and re-verification be made within 1 week thereafter. No. G application stands disposed of.
Number 4.
Yes, I'm reading out the operative portion. In the facts and circumstances, this application stands allowed in part. The suit be finally decreed in part. Plaintiffs do get a final decree in accordance with the terms of settlement dated 16th January 2025, entered into between the plaintiffs and the defendants number 1, 3, 4, and 5, and on admission by the defendants number 2, 6, 7, and 8 of plaintiffs' right as per the terms of settlement dated 16th January 2025. Plaintiffs to get a decree of declaration declaring their absolute rights with regard to suit property situated at 6 Western Street, Calcutta, says 7,01,000 more fully described in the schedule to the plaintiff. Plaintiffs do get a decree for possession declaring right to take possession of the property at 6 Western Street, Kolkata, 7,01,000 from date. As the preliminary decree is still in force with regard to the defendants of the suit, the defendants are given 2 months' time to hand over possession of the suit properties which does not fall within their shares as per preliminary decree and take possession of those portion of the suit properties which are within their shares. The handing over and taking possession shall be in the presence of the special officers. The defendants shall also ascertain the municipal tax and pay the same within 2 months. So and so are appointed as special officers. Learned special officers upon notice to the defendants fixed date for handing over possession. The possession shall be handed over and taken in presence of the special officers. Learned special officers shall submit report on 15/1/2026 before learned regular bench having determination. Fix 15/1/2026 for report of special officers. So application stands disposed. The suit decree is decreed in part.
I'm very grateful.
Disposed.
At number 5 and 6.
Item number 5.
5 and 6.
5 and 6.
6 to nahi, শুধু 5.
Item 4 এর নাম।
Yes, item 5.
হ্যাঁ, অনলাইন থেকে তুলে লাগবে না।
Item 5, your
Yes,
lordship.
when can you come ready? Let the matter be disposed.
Yes, I need certain some more time to prepare the
So
complete.
her evidence is over.
Her evidence is over.
So
Now-
your evidence, you are for defendant?
I am for the plaintiff, 2 series. 2 series, your lordship will kindly extend the time for me to
My
file
lord,
the-
extension of one single
list
event
of
is
dates.
attempt to murders, my lord.
Huh?
And all encroachment inclusion in our,
question is,
my lord, on
Are
the
you
relationship
sure you
of
can
plaintiff
come with the
property.
evidence on the next date?
My lord,
14th.
only the
14th, my lord.
only the difficulty, my lord. This is the second round of litigation.
Otherwise, I do one thing. Let it be by way of commission.
Yes,
No,
my lord.
That can be done.
May I
Yes,
just
my lord.
may I just indicate? This is the second round of the litigation. Now the entire pivot of this litigation rests on an Orponnama. The issue which the court has to decide in this matter
The
is the
matter has
Court has decided on Orponnama, my lord,
Please
6th
don't-
October
don't-
The
2000.
evidence has to be adduced by you, your client.
Yes, yes.
So
Now
why
the
are you not adducing
Orponnama, the
evidence?
original Orponnama is untraceable. It was exhibited in the 90s before the court. Thereafter, it could not be traced. So there was directions upon the department to produce that Orponnama. So we made inquiries before the registry office. Directions were the person to directions to produce, give me the certified copies. Now my learned advocate on record went to the registry office. They said they cannot give us the certified copy of the Orponnama. It is 1800 document. They can bring the original record, the volumes, the old volumes, and produce it before the court if they are so called for by way of a subpoena. So that's it. And we will just prepare a list of dates for my lord, and then we will proceed to give evidence.
So I'm keeping it after 2 weeks.
3. Subpoena.
My lord,
you have
kindly
to-
consider this is a partition suit, my lord. 10 owners are aligned in
The-
partition, my lord.
The
And our victims,
your plaintiff number?
One.
1 and I am for the
Plaintiff
2
number
series.
1 and plaintiff number 2
Two-
series
to
are
be two-
present. You are
And different number 3A, my lord.
plaintiff number
My lord, it
1,
should be recorded that plaintiff number 2B2D is opposing partition in spite of
Plaintiff
being
one and
son of
plaintiff
original
number
plaintiff.
2B series and defendant number
3, my lord.
3
3A.
are present.
Let
Uh,
3A.
Mr. Dotto appearing for plaintiff number 2B series, prays for time to come with the list of dates and adduce evidence. Such time is granted. The plaintiff number 2 series shall come ready on the
Of
date
witness
fixed.
action.
Let this matter appear on
14.
28/11/2025. The time fixed for evidence is peremptory.
My lord, only one thing, then the direction be given upon the registry office, RE Calcutta, to bring the volume, my lord. He has to bring the volume because that's the only document I am going to tender. He has a
It is
direction.
already
A direction
copied
has to be,
this,
a direction has to be
but it should
given,
be noted, my lord.
has to be given upon
Okay,
the.
Very important note,
The
my lord.
plaintiff shall take steps to issue summons upon the Register of Assurance, Kolkata, for adducing necessary evidence.
For bringing this volume,
For bringing the
volume or containing the Orponnama involved in this matter. My lord,
Secondly, my lord, it should be added that copy of Orponnama has been filed by
it's a
son of
copy,
plaintiff
Xerox
number
copy cannot go, either the original or the certified
it
copy.
has been
Xerox
filed.
copies cannot go.
It
She
has
does
been
not
filed.
understand law.
GA 1784 of 2016 and
Please
Justice
let me
Ranjit
record my
Kumar
order.
Bagh has passed an order on that.
Okay, learned advocates for the plaintiffs number 2 series shall take necessary steps in the meantime to issue summons upon the Register of Assurance to bring the records containing Orponnama with regard to the
Present matter.
present suit property.
My lord, my
Great.
position, my lord, appointment of commissioner of partition for my position, my lord, and for other 10 owners, my lord, who are victims, my lord. Our position,
After evidence, I shall
After-
dispose the
Great.
my lord, in
I'm
the
really great.
this plaintiff number 2B2D is trying to murder us and using this as
Receivers are there,
Keep it-
directions are,
my lord. Our
receivers are there.
position has been destructed, my lord. If I am murdered, who will be responsible, my lord?
Okay, come with application that they
My applications are pending, my lord.
no, against this defendants, I shall cause inquiry.
And by different, the
Great.
advocate Arindam Pal is presenting an will without probate, my lord. It is an High Courted first decorum যদি আমি appear in person করি আমার কথাটা শোনা অ্যাডভোকেটদের কথা নয়